two of those questions. Are both sides ready?
State's ready.
Defense is ready.
All right, Mr. Aguilar, you may proceed.
Thank you. Good morning. My name is Wilfred Aguilar, and I'm an assistant county attorney here in Travis County. Ms. Margaret Moore is your elected county attorney, and I was appointed to the position of assistant county attorney by Ms. Moore about 10 months ago. I'd like to begin by thanking you for being here today. Without you, this process could not take place. If we don't have jurors, we cannot have a jury trial. And a lot of people fail to respond to their notices for jury duty, and we do appreciate those of you that have taken those to heart. This portion of the trial, as the judge told you earlier, is the Voir portion. My French is terrible. I'm much better at Spanish than I am at French. That literally translated means to speak the truth. During this part of the trial, both myself and Mr. Gallardo, the defense counsel, will be asking you questions, and please understand that our questions are not designed, well, to some extent they are designed to pry into your personal life, but there's good reason for that. Mr. Gallardo and I are both after 6 jurors, and when I say 6 jurors, I mean 6 impartial jurors. 6 jurors that can listen to the evidence in this case, and when the time comes, render a verdict that's fair and just to both the state side and defense counsel side. We're both after one thing in this trial, and that's to see that justice is done. And unless you listen to the evidence fairly and impartially, that cannot happen. And that perhaps is the most important thing about a jury trial. My voir dire will probably be a little longer than Mr. Gallardo's. I'll probably cover certain topics that Mr. Gallardo will go over with you when his turn comes. I'll try and make this as quickly as possible and as painlessly as possible. This case deals with what's commonly called DWI, driving while intoxicated. Style of the case is the state of Texas versus Victor Alvarez. Mr. Alvarez is charged with driving an operating motor vehicle on a public road within the county of Travis, state of Texas, while under the influence of an intoxicating liquor. Is there anyone here who's, amongst the jury panel, is there anyone here who knows anything about the case? Have they heard anything about this particular case, either today or prior to today? Is there anyone here who is acquainted with either Mr. Gallardo or myself, or the defendant, Mr. Aguilar? The police officers who will be called to testify in this case are seated over to my right. I'll ask them to stand. I won't give you all of their names, but I would like to ask if any of you are acquainted with any of these police officers. In Texas, the defendant, as it's true throughout the United States, defendant has certain rights, and these are very, very important rights. Now, I'm going to go over these rights at this time. I want you to pay very close attention, because these are important. As I said earlier, the purpose for both of us being here, defense counsel and myself, is to see that justice is done. And unless you give proper respect to these rights, that cannot happen. His first right is that he has a right to a jury trial. You're here today because the defendant has requested a jury trial, which is his right. He's requested that his case be heard by a panel of 6 people, 6 jurors of his peers. Is there anyone here that feels that their lives are so busy, so complicated, that they can't take time out to sit through this kind of proceeding, and they're going to hold it against this defendant simply because he's asked for a jury trial? Is there anyone here who feels that there is something in their lives that's very, very pressing, and that perhaps they might be too distracted during the course of this trial to perhaps listen to all the evidence fairly and impartially? His next right is representation by counsel. He has a right to be represented by a counsel attorney of his own choosing. In this case, he's chosen Mr. Gallardo. And Mr. Gallardo, I well know, is a very competent attorney. Is there anyone, he has a right to confront witnesses. Now, what that means is that he has the right to be present during all the proceedings in this trial. He has the right to listen to and see the witnesses that are going to give testimony against him. He can excuse himself if he wishes after the trial has commenced, but he must be here during the initial phase and the final phase. He has a right against self-incrimination. He has the right, in other words, that means that we cannot force him to testify. He cannot be forced to testify in this case. If he chooses not to testify, you are not to hold that against him. That is no evidence. It's not evidence of guilt, neither is it evidence of innocence. And that is a very, very important right. Is there anyone here who feels that if the defendant chooses not to testify in this case, that they will consider that either evidence of guilt or evidence of innocence? As I said, that is no evidence, and you should not concern yourselves with that fact. Finally, he has the right to subpoena witnesses, the same right that the state has. We've subpoenaed our officers. I'm not sure if Mr. Gallardo and his defendant have subpoenaed any witnesses on their behalf, but he does have that right. Thus, if someone other than the officers was present at the scene, he has the right to subpoena that person to be here to give testimony, because that person has knowledge pertinent to the facts in this case. And he has that right. Now, your role in this trial will be that of the trier of fact. The judge will make decisions concerning the law in this case. During the course of the trial, there will be certain objections that will be raised, either by myself or Mr. Gallardo. Please understand that when we make those objections, they are made not to cloud the trial, not to cloud the issues, but merely to be sure that only competent, admissible testimony is admitted for your hearing. The testimony will all come from the witness stand, not from my mouth and not from the mouth of the defense counsel, not through our objections. It will come from the witness stand. The law, however, on certain pieces of evidence, will be given to you by the judge. If a certain piece of evidence comes in and a proper objection is made and the judge instructs you to not consider that piece of evidence in making your determination of guilt or innocence, is there anyone here who feels that they cannot follow the judge's ruling regarding the law in the case, whether that piece of evidence is admissible or not, and who will think, well, I'm just as capable at that as that judge is in deciding as what should or shouldn't be considered? Is there anyone here who feels that there might come a time when they will refuse to follow the judge's instructions on the law in the case? Can I get a promise from all of you that you will adhere to the judge's instructions regarding the law in this case? As I mentioned earlier, your job is to determine, is that of the trier of fact, to determine what happened on this night. Was Mr. Alvarez driving under the influence of an intoxicating liquor? As the trier of fact, you will be determining the credibility of the witnesses. Now, you can believe all of a witness's testimony, part of a witness's testimony, or none of a witness's testimony. How do you decide what to do that? How do you decide whether to believe all of a witness's testimony, part of a witness's testimony, or none of a witness's testimony? One way you do it is by judging the demeanor of a witness. Does he look and act like a person is telling the truth? How does he respond to the questions? Does he respond in a calculating, deliberated manner, or is it a spontaneous thing, something that he's just giving you? Spontaneity, I think, is a very important thing. Does the testimony that a certain witness gives, does it make sense? Does it follow logically, reasonably? Those are things that you must look at. Those are things that you must consider in determining whether or not to believe a certain witness's testimony. you should also consider, what does the witness have to gain by that testimony? Is the testimony self-serving? Is there a reason for that testimony? Or is there no reason whatsoever? Those are all things that you should and you must consider. The defendant in this case stands charged with the offense of driving while intoxicated. And that is only a charge. It's an allegation at this point. You must consider this defendant innocent. You must presume him innocent until the state has met its burden in convincing you that he is guilty of the charge beyond a reasonable doubt. That's very important. That's not to say that this defendant did not drive while intoxicated. That's merely to say that there's a presumption of innocence. Now, the burden of proof in this case is the state's. We must come forward with the evidence to convince you beyond a reasonable doubt that this defendant on January 10th, 1981 did drive and operate a motor vehicle while under the influence of intoxicating liquor. We have a burden to prove the facts with the facts that he is charged with the facts that he is charged with. We must prove that he, 1, drove and operated a motor vehicle, that he did so upon a public road in the county of Travis, state of Texas, while intoxicated. And that's all we must prove. We must not prove what color the sky was that night, whether it had a red hue or a gray hue, whether there was a moon out or no moon. We simply must prove the elements of the offense. Now, there will be some conflict in the testimony. Somebody may say he was wearing shoes, somebody may say he wasn't wearing shoes. But that is not an element of the offense. If there's a reasonable doubt, the reasonable doubt should come from one of the elements of the offense. A doubt as to whether he did drive the car. A doubt as to whether he was in fact intoxicated. Not a doubt as to what color shirt he was wearing. Those are totally irrelevant. Now, what is a reasonable doubt? This is perhaps the hardest thing in anyone's voir dire, is to try to explain a reasonable doubt. Some people will tell you that it's the doubt that a reasonable man would have. Reasonable men differ in what a reasonable doubt is. I prefer to define it as a doubt that's grounded in logic and reason. Something that you can point to and say, they didn't prove this. I have a doubt about this. And it should be an element. As I said earlier, not what color of clothes he was wearing. A conflict in the testimony does not in and of itself create a reasonable doubt. If two people see a traffic accident, I bet you $100 that you're going to have two different versions of what happened. They may be telling you the same thing. They may come to the same end result. But the means by which they get there, what it is they say to get to that end result, will be different. Again, a conflict in and of itself is not a reasonable doubt. If there's a conflict in the testimony, you as jurors, if you do your duty, must resolve that conflict. Now, I don't think there will be too much conflict as to whether or not this defendant did drive a motor vehicle on this car. I don't think there will be too much conflict, if any at all, about whether or not it was within the county, state of Texas, county of Travis, state of Texas, or whether it occurred on a public road. I think there will be conflicting testimony as to whether or not the defendant was intoxicated, driving under the influence of an intoxicating liquor. Now, what does it mean to drive under the influence of an intoxicating liquor? Well, most people would say, well, that means he was drunk. All right. Well, what does it mean to say that someone is drunk? Does it mean that he's commode hugging drunk? Does it mean that he's staggering a little bit? Does it mean that he slurs his speech? What does it mean? It can mean all those things. But we have a definition, a legal definition, as to what intoxicated is when referring to driving while intoxicated cases, driving under the influence of an intoxicating liquor. I believe that the judge, after you've heard all the evidence in this case, will charge you as follows. A person is deemed to be under the influence of intoxicating liquor within the meaning of the law when he does not have the normal use of his physical or mental faculties by reason of the use of intoxicating liquor. Now, by that definition, you can be intoxicated when you're not falling down drunk. You can be intoxicated if your judgment is impaired. Normal use of his physical and mental faculties. The law in issuing you a driver's license, those of you that do have driver's license, and allowing you to drive in the state, presumes that you will have the normal use of your physical and mental faculties every time you get behind that wheel. They presume that your reactions will be normal. Your reaction time will be normal. They presume that your judgment will be normal. This is the definition that you must apply to the case. This is the definition, again, that I believe the judge will charge you with when it comes time for you to enter the jury room and deliberate on this case. Is there anyone here who feels that they cannot follow this definition? And I get a promise from all of you that you will apply this definition to the facts in this case, the definition that I believe the judge will give you. Is there anyone here who feels that they don't understand the definition? Thank you. Now, it's not against law to drive and drink, but it is against the law to drink and drive when your judgment is impaired, when you're intoxicated, when you do not have the normal use of your physical or, and that's or, not and, but or, mental faculties.
Excuse me, may I approach the bench?
Yes, ma'am.
Yeah, you have that bench out so everybody can hear it.
I don't, I was just saying, I would have read the pleadings beforehand to know whether or not he had pled in the disjunctive. It's not widely accepted locally, but I think that it's a good objection that you ought to insist that they plead factually whether or not it was by loss of physical or by loss of mental, so that I would then cut out his chance to be able to play it either way depending upon how the evidence came out most persuasively later on in the trial. So my objection now is that he be limited to whichever his pleadings are, whether it's loss of mental use or physical use.
Understand? So you say.
Play.
Please understand again that that was one objection that I spoke to you about earlier. Again, don't hold it against Mr. Gallardo for making that objection. It's not to trying to keep anything from you, simply trying to keep this trial fair, as I said, to both his client and the state. And I appreciate all of Mr. Gallardo's objections. Now, there are two ways to prove that.
Excuse me, I'm sorry to interrupt again. I do need to ask one other question. I think there would have been some ruling on the pretrial hearing concerning whether or not the breathalyzer was properly administered, either the warm-up problem or the failure to observe because the officers were doing something else for the 15. I think they were filling out forms or something. I need to ask for a ruling because if he's going to start talking about breathalyzer information and that was suppressed at the pretrial because the test was not properly administered, then I'd like to have it excluded from the report.
There is no suppression.
At this time, I'd like to object to any testimony concerning breathalyzer information.
Overruled.
And have a man of running bill.
You may have a running bill.
Thank you again, Mr. Gallardo.
You have 10 minutes, Mr. Aguilar.
Thank you, Your Honor. There are two ways in which the state can present testimony to prove to you that an individual is in fact intoxicated. One is the opinion testimony of police officers. We will have that in this case. These are officers that have been trained and have a great deal of experience in determining whether or not an individual is in fact intoxicated. We will also have scientific testimony in the form of a breathalyzer test. In this case, a breathalyzer was administered, and the defendant took that breath test. And the results of that breath...
Excuse me, Your Honor, I'm going to object to any discussion about the facts of the case until the jury has been sworn.
You want to sustain the objection, Mr. Aguilar, the results have not been admitted at this time.
All right, Your Honor. Now, in this state, there is a presumption that when an individual registers a certain amount on a breathalyzer instrument, he is presumed to be intoxicated. I believe that the judge will charge you, when it comes time for you to deliberate, with the following charge. You are further instructed that if it is shown by chemical analysis of a person's blood, urine, or other bodily substance that there was at the time of the act alleged 0.10% or more by weight of alcohol in the person's blood, it shall be presumed that the person was under the influence of intoxicating liquor. However, such amount of alcohol in the blood of the person merely raises a legal presumption that such person was under the influence of intoxicating liquor, which presumption may be overcome by competent evidence showing that such person was not under the influence of intoxicating liquor. Now, that is a legal presumption. That is one that a presumption that you as jurors must adhere to if the state presents competent testimony of 0.10% or more by weight of alcohol in the person's blood. Is there anyone here who feels that they cannot adhere to that presumption if the state presents that competent testimony? Anyone at all? As I said, there are two ways in which you can prove an individual is intoxicated. There's state law, which allows a jury to return a verdict of guilty in a charge of driving under the influence of intoxicating liquor where there is only opinion testimony. In this case, we have both the opinion testimony of the police officer and the scientific evidence which we will present in this case. Now, this is a Class A misdemeanor. A Class A misdemeanor carries a punishment range of from $50 to $500 and from 3 days to 2 years in the county jail. Is there anyone here who feels that because this defendant could possibly receive a fine of up to $500 and be sentenced to up to 2 years in county jail, that there is no way that they could return a verdict of guilty in this case? If the facts dictate and if you're called upon to assess punishment in this case, is there anyone here who would automatically rule out a fine of $500 and up to 2 years in the county jail? Now, the reverse of that. Is there anyone here who feels that they could not, if the facts dictate, return a verdict of guilty, and if they are assessed the duty of assessing punishment, assess a $50 fine and 3 days in jail, that's just too little? There's no way they're going to give that person that little, this defendant that little punishment. In Texas, there is what is called a bifurcated trial. That means that you have the fact-finding portion of the trial, then you have the punishment phase of the trial. I don't know if Mr. Gallardo intends to go to the punishment phase of the trial and have you, the jurors, assess punishment in this case. But if he does, remember your promises. The facts dictate. You can return a verdict of guilty and assess a $500 fine and up to 2 years. And if the facts dictate, you can return a verdict of guilty and assess a $50 fine and 3 days in jail. What that means through your promises is that you're going to consider the entire range of punishment, which is what both I and Mr. Gallardo want you to do.
4 minutes.
All right, thank you. This time I would like to speak with each of you directly. Mr. Burleson? I see here that you're a student.
Yes.
What do you study?
Law.
How long have you been here? Are you studying here at the university or?
Yes.
The reason I ask that is because I have known someone who lived here in Austin, went to school in San Antonio to study law, so. Are there any questions that you'd like to direct to me regarding anything that I've said here today?
No.
Do you feel that a police officer's testimony, simply because he's got a badge, a uniform, perhaps a gun, that is more credible than the testimony of other people? Do you have any relatives that are in law enforcement?
No.
Is there anyone else in the panel that has relatives that are in law enforcement?
Yes, I do.
And my husband is in law enforcement.
What does your husband
Well,
do?
he's in the Attorney General's office, and he represents the state in federal habeas corpus proceedings.
Is the fact that your husband does work in the area of law enforcement, will that influence you in this case? Do you feel that that will force you, make you, bias you in favor of the testimony that the police officers will give? Do you think that you can set any biases that you may have, set those aside and judge the fact in this case fairly and impartially?
Yes, I do.
You mentioned you had someone that was,
Yes, my brother works with the DPS.
okay, what does he do?
He's a patrolman, hourly patrolman.
Do you like your brother?
Yeah, always have.
I've had jurors tell me my brother's a police officer, but I can't stand him. And you feel okay about your brother?
Yeah, I see him about 4 or 5 times a year.
Same questions. Will that influence you in this case?
Yeah.
I mean, let's face it, you probably have some biases, but can you set those aside? That's the important thing.
I think so, yes.
And judge this case fairly and impartially. Mr. Bird,
Yes, sir.
what do you do for a living?
I'm a businessman.
Okay, what type of business are you involved in?
It's kind of a generalized computer stereo business. We fix all kinds of electronic gear.
What kind of electronic gear?
Home computers, home video sets, home stereos, high-tech type stuff.
Do you have any questions that you'd like to ask me regarding anything that you've heard us say? Is there anyone on the panel who, because of some experience either they've had or a relative of theirs has had with law enforcement personnel, with the criminal justice system, feels that they cannot act as fair and impartial jurors in this case? Not at all. Is there anyone here who feels that this defendant, simply because he's charged with this crime, must have done something wrong? I think that my time is about up. I would have liked to have taken some more time with each of you individually to find out a little bit more about you. But this time, I think it's only fair that I tell you something about myself. As I said earlier, my name is Wilfred Aguilar. I was born in El Paso. I'm married. I've got 2 children. I'm Catholic. I've never served on a criminal or civil jury. I have been charged with a traffic offense from time to time, and I have also been charged with a misdemeanor. That hasn't stalled me with the criminal justice system either. I told you a little bit about myself. I found out a little bit about you. I thank you for your time. And again, please remember, we're both after the same thing, and that's to see that justice is done. And the most important people in this process is you. And the only way that justice is going to be done is if you view the facts fairly and impartially. Thank you.
Please report. Good morning. My name is Juan Gallardo. I represent the person who's called the defendant in this case, Victor. He has asked that 6 citizens of Travis County listen to the evidence, believes that he is innocent, that he should not have been arrested in this case, and he's going to ask for 6 of you to listen to the evidence because he has confidence that when you listen to the evidence that he'll be vindicated. So what we're talking about here this morning is that we're going to pick 6 people who can be fair, who can put aside as much as possible whatever prior experiences or whatever else is going on in their life to take the time to give Victor what he's entitled to, what you and I are also entitled to. Now, the prosecutor, I think, sort of suggested that, well, this is a crime, and he didn't really get around to the seriousness of the charge until he started talking about the range of punishment. I'm going to disagree with him in a couple of places, but I have some questions for you. Let me suggest a couple of things. First, there aren't any, there's none, there's no way, it cannot happen that you ask a stupid, a foolish, or any kind of question that, in other words, if there's something that's bothering you, you ought to just raise your hand. You want to talk about it, you just want to, there's something that maybe I kind of got close to, or the prosecutor discussed indirectly or directly, anything that's sort of bothering you. Remember that we're going to be asking you questions now, but the problem is that once you are selected, that's it. That's the last chance we get to talk to you. After that, it's extremely formal. It has to be done in open court and in writing. And now is the only time that we can communicate back and forth as people. And so this is the only time that you have to do that, the only time that I have to do that. And so I'm going to ask you to feel free. Let me ask you to, if I may, so I can save as much time as possible, I'll ask you as a group, please, all of you who are students, raise your hands. You're students. Okay? Have any of you been in the military before? I didn't quite catch everyone in the notes. Those of you who either have been yourself or someone in your family is in law enforcement, would you raise your hands? Okay. Now, I noticed also, Ms. Ford, that you have been a witness in a case. What sort of case was that?
Well, it was an assault case at a bar.
Did you know the person who was either charged with the crime or the assaulted person?
I knew the assaulted person.
I don't mean to pry, and let me say this to all of you, that if there's something that you would rather not talk about in public, you understand the significance of what we're doing here this morning requires that I may have to ask you some questions that are personal in nature. If you'd like to discuss them at the bench, in private, we can do that, and that's perfectly all right. How well did you know the person who was assaulted?
Well, it was my date.
Were charges filed?
Yes, they were.
And how did the trial come out?
The person that assaulted.
Ron, I don't think it's proper for the defense counsel to ask this witness whether the defendant in that case was found guilty or not guilty. I don't know if it's relevant. Overrule the objection.
Let me ask you if you were satisfied with the results.
Yes, I am.
Did you think that justice was done?
Yes, I did.
Did you have an opportunity to watch much of that trial, or were you simply out in the hallway on those hard benches for a long time?
I simply was a witness. I worked during the day, and so I couldn't watch the trial.
And your friend, did you have any conversations with your friend afterwards about his feelings about the trial?
Yes, I did. He felt that justice was done too.
I want to talk about a couple of areas. First is something called the burden of proof. The burden of proof is, I'm not going to try and straighten out the god-awful mess that we're in because lawyers and judges, scholars of the law or whatever, who've tried to define it, who haven't gotten around to doing it in a way that we're all comfortable with, let me suggest that we look at it in a sort of process way. The burden of proof is that mechanism that allows you to judge the facts. It tells you what weight to give them. It tells you how to handle them. They're not just facts, or the testimony of the evidence as it comes in. They're not just things to be processed of even weight. You have to evaluate and give weight to what you hear, and then you have to decide whether or not what you hear in total is sufficient to justify convicting someone of a crime. So if we try to break the words down individually beyond a reasonable doubt, you're going to bog down. What you need is the gut feeling of, is it enough? Are we going to say Victor's a criminal, he's convicted, put all the consequences of a criminal conviction? Does this evidence justify that? Is this the standard that we want to have applied? Does that make any sense to you? I didn't ask you if it was helpful. I'm not sure there's any way you can get to a helpful description of beyond a reasonable doubt. It must be clearly understood, though, that we're not just looking for, well, sort of guilty, or maybe more likely guilty than not. Do you understand that? I mean, it's beyond a reasonable doubt because we want it to be really satisfied. I can sleep with this decision. Is that your understanding of beyond a reasonable doubt? People might ask you at work or in family or in school, your brother, for example, who's with the highway department, may ask you why it was that you came with such a decision. Do you think that you'd be comfortable going back and telling your brother that you found him not guilty? Just kind of looking him in the face and say, that's the way we felt about it? I mean, assuming that the evidence supports that. That's what beyond a reasonable doubt. That's the function of a jury. It is the way that citizens or people, as the Constitution, I'm not going to get into the Fifth Amendment with you, but Victor, let me ask you, does it bother any of you that he may or may not be a citizen? I mean, do you think that people who come here from another country ought to just sort of take whatever happens to them? I know we can all get kind of burned up from time to time about what happens to our citizens in other countries. There's not anyone here who thinks that we can sort of straighten out Nicaragua by what we do here, right?
No, I don't agree with you. That shouldn't be.
And let me ask you to do this. If I ask one of those questions just like that, and it doesn't make a bit of sense to you, don't assume it makes any sense. Just raise your hand and say, I didn't understand that. Would you do that again? All right? I'm not going to be doing my client or you any good if I just talk gibberish. The question is, then, you feel absolutely comfortable with the idea that we're going to use the same standards, the same procedures as we would have applied to ourselves. Is that right? And it doesn't make any difference. Let me ask you about speaking Spanish. Do any of you speak Spanish?
I can speak just a little bit.
So you might have some better ability to get through a heavy accent, you think?
Oh yeah, I grew up in, I was born in Pontiac, Michigan, and then
There are a
moved
lot
to
of Yankees up
California.
there, yeah.
Well, we got out of the cold, went down to Southern California, and so when I grew up, a lot of people spoke Spanish and English, so I'm used to having an accent.
Okay. Have you ever been around people who were speaking in a language other than English and see that people around them have some difficulty understanding because of the accent?
Oh, sure.
Have you ever seen that?
Yes, sir.
Mr. Daly, have you ever been extremely angry?
That's Mr. Bird, sir.
I'm Mr. Daly.
Yeah. Have you ever been extremely angry?
Oh, I guess everybody gets angry sometime. Not too angry, no.
Well, have you ever gotten so angry that you just couldn't speak properly? I mean, just choked up?
No, I don't think so.
Ms. Ford, when your friend was assaulted, did he have some difficulty expressing himself at the time that people were pounding on him?
Well, people didn't pound for very long. Other people interceded and dragged him off. He didn't assault back.
Well, what about when he was later trying to talk about it, either to the police or witnesses at the time? Did you notice any difficulty?
He wasn't particularly angry. He was angry, but not livid. I mean, it was the person that assaulted him was drunk, and I think he felt he was out of control of himself.
Were you able to observe those events leading up to the assault?
Yes, I was.
And the person who did the assaulting, had that person been in or around or near your table for any length of time?
Yes, he had.
So you had some considerable opportunity to watch them. And
Well, no, because the events leading up to the assault were very sudden, and really I didn't notice the other person.
did you know them at all before then?
No.
What was it about their demeanor that made you think that they were drunk?
Well, the person was slurring his speech and just seemed out of control of himself. He wasn't that coordinated as he was making the assault, and he was just sort of out of control. And later on at the trial, I understand that it was proven that he had been drunk or had had quite a bit to drink.
We're not fooling anybody to say that alcohol can affect you, right? I mean, no one's trying to say that to you, right? We all understand that. Mr. Burleson, you are Baptist, is that right?
Yes, I am.
Does that mean that you don't drink at all?
Yes, it's true.
Does that mean that you also think that others ought not drink?
No, not necessarily. I don't have any objection to them drinking.
Well, that's not exactly my question. It's sort of closer to, would you feel less of someone if you had heard that they have been having something to drink? Are you married?
Yes. No, I'm not.
No. Okay.
I don't know what you mean by feeling less.
Less respect. If there were someone that you knew that you had a lot of esteem for, and then you saw them drinking, would it somehow bother you that they were drinking, or affect your feeling about them?
No, not necessarily.
You're willing to say then that it's so you'd rather not drink yourself, but you're not going to put any sort of value or moral judgments on whether or not someone drinks. It's not the drinking that's the problem.
Yes, I would say that.
Do any of you have any problems with someone drinking?
I don't drink myself, and I don't approve of it really.
By saying that you don't approve of it, and let me say you're absolutely entitled to whatever opinion that you have or want to have. I'm not here, or no one's here today to make any judgments about your opinion. Would you say then, how long have you felt that way?
Well, I'm a member of the Church of Christ, and I've always been taught that it's not, it's a sin to drink.
Mm-hmm. Well, I wonder if I could ask you to approach the bench, please.
Mark, you stand in place and assume that you're at the bench.
When you say that that it is a sin, you're saying then that they've done something that is wrong, not just sort of in a social setting, but it's fundamentally wrong. Is that right?
Yeah. I guess.
I mean, what you're saying is that you have these scriptural bases for the belief that one ought not drink, and that there's some act defiant of God involved in the drinking.
Yeah, I guess that's kind of how I feel about it.
How often do you go to church, sir?
Every Sunday,
Wednesdays?
sometimes.
Would you say that you and your family have always been very strong members of that church?
I think so.
Do you think that it might be difficult to explain to your church members? Do you have any office in the church?
No.
Do you think it might be difficult to explain to the members of your congregation that you had an opportunity to find someone guilty of driving while intoxicated and the use of alcohol, and that you set them free?
I wouldn't talk to them about it.
You mean you'd rather not talk about it than have to face them?
I'd rather they wouldn't know.
I understand that. Do you think then that it might have some sort of unconscious effect on you when you're making a decision, when you're asked to vote on guilt or not guilt, do you think that there might be some unconscious resistance to finding someone innocent?
I don't know. I heard what you all explained about the elements of the crime and what has to be shown and the way we're supposed to decide. And it seems that I'm a fair-minded person. I could probably...
I have every confidence that you'd make what you thought was the right decision. Now, what I'm asking you, though, is we sort of need to perceive it like an object at rest. It's not moving in any direction, and it moves freely. It's not subject to inertia. Does that make any sense to you? There's not any resistance. You can be persuaded by the force of the evidence, and you're not resisting that evidence in either direction.
I think so, yeah.
I'd like to challenge him for the cause.
Is it Mr. Daly?
Yes.
Mr. Daly, earlier you told Mr. Gallardo that you would have no qualms returning a verdict of not guilty if the facts of the state failed to meet its burden beyond a reasonable doubt.
Yeah,
And you said that you could. I also asked you if you could set aside, during my portion of Voir, your personal biases towards, because of your background, whatever. In this case, your biases about drinking. You don't drink, that's fine. We're not trying someone for drinking. We're trying someone for driving a motor vehicle while he's under the influence of intoxicating liquor. And you set aside your own personal feelings about drinking and judge this case fairly and impartially on the facts and apply the law as it's given to you by the judge to the facts.
Yeah, I think I can do that.
I would oppose it.
Mr. Platt, excuse me, Mr. Daly, the court has a question of you. Do you feel that the defendant is starting out this trial in your eyes with a strike against him because of your religious beliefs concerning drinking and the fact that obviously he had been drinking? Is he going to have to produce anything to remove that black mark in your eyes from your mind?
Well, I think I can separate the two. I don't approve of his drinking. That's against my religion, but I think I can look at the...
In other words, is he going to have to do something to remove that feeling from your mind?
Who the defendant?
Yes.
I don't think so.
Overruled objection.
Note my exception. I guess
Now you're back to
I'd like to ask for a mistrial.
overruled.
I want to ask you whether or not, are any of you chemists or have you studied a lot of chemistry? I'm not going to ask you for any formulas. Come on, fess up. All right. What we're talking about in the use of alcohol is that it can have an effect. That's clear from our own experience. It's clear from what we have heard about how things happen in this society that can have an effect. Involved in the burden of proof is that they must prove that Victor was intoxicated within the meaning of the law. That is, he had lost the normal use of his mental and physical faculties by reason of the use of alcohol. And one of the places that I disagree with the state's analysis of that phrase is because I believe that the operative word is by reason of the use of alcohol. How many of you have had one drink on an empty stomach and immediately felt something? Raise your hands. Were you ready to... and I'd like to add... Did any of you just jump up and turn yourself in for being intoxicated? In other words, you're saying that you were able to make a judge of the situation. You knew you could feel some effect, but you also knew that you were in control of yourself. And you felt that as an adult you were entitled to make that decision. Isn't that right? So that the operative expression is, by reason of the use of alcohol, the failure to control the body or the mind has reached such a point that we will no longer permit it to operate a motor vehicle. Does that make sense to you? Some states won't let you drink and drive at all, or won't let you have alcohol in the car. Texas takes a position that it is the dangerous situation we want to avoid and not the drinking. You all think that that's all right. You can accept that standard. I'm going to disagree in a second place with Wilfred, and that is where he talked about the presumption. He sort of skipped across the place where he talked about that the burden of proof is always on the state, never leaves the state. I'm sure, Mr. Burleson, in your classes you've heard that, and you know that that's true. No matter what happens in a criminal case, it is never the job of Victor to have to come forward and persuade you.
Jack, presumption, once the presumption is established, it's most certainly the burden is on the defendant to come forward with evidence to rebut that presumption. That is a complete mistake in the law.
I think, Your Honor, that, and if I don't have the citation, the New Hampshire case that went to the United States Supreme Court saying that it was in the murder where they had the presumption, the murder rule, and the Supreme Court said, sorry, you can't have an automatic mandatory presumption against the defendant. All you can do is say that the jury is entitled to believe that evidence alone and no other. I'm afraid that Texas has used a misnomer and called it a presumption, but the Supreme Court says constitutionally the burden never shifts to the defendant.
Ladies and gentlemen, the jury panel, you will receive the law from the court and be guided thereby. We continue.
Thank you. In the idea that there's a presumption, Wilfred suggested to you that if he presents certain kinds of evidence, you must adhere to that presumption. Not in America, and certainly not here in Travis County. We're going to tell the state, and I think that it's absolutely right, it's the way the system works. We're going to say to the state, the police, the prosecution, that you must prove, that is, you must persuade, and here we are back again to that gut feeling. We must have that gut feeling that I can wake up with tomorrow and tell my friends and family about that person was guilty. And the evidence has to persuade us of that. And the defendant, Victor, does not have to stand up and persuade you otherwise. Do you all understand that and accept it? And the judge is going to ask you to follow the law. I'm going to ask you to follow the law. And remember that the important phrase in the court's instruction to you is beyond a reasonable doubt. And the translation of that is that real, solid feeling that this evidence justifies a conviction for a crime. You understand that? Thank you. Let me talk a little bit about what a driving while intoxicated case involves. As a former prosecutor, I can tell you that I have stood in front of jurors, such as yourself, and asked them to find someone guilty. I have listened to police officers tell me that they had seen this or that or the other, and I have gone in based on my own belief in what they had said and asked the jury in support of that evidence. That experience, though, taught me a number of things, and the first important thing I'm going to ask you to watch for in this trial is there is sometimes a belief on the part of police officers or prosecutors that once you see a particular physiological reaction, that there can be only one cause for it. You'll recall, I asked you a moment ago if you'd ever been so angry that you couldn't talk. Have you ever cried and had your eyes get bloodshot? Have you ever run up a flight of stairs and been out of breath and dizzy? Did you ever work in the field, anywhere, the sun get hot on you and be unsteady on your feet? Have any of you ever played football or track or any of those sports? I think you might, if you watch TV sometimes, see people just sort of keel over, and you know they're not drinking while they're out playing the game, right? And that, what I'm suggesting to you is ordinary common experience, and that is that there may be more than one explanation for a physiological body response or activity. Do you all believe that? So, what I'm going to suggest to you is that in order to find Victor guilty, you must believe that whatever evidence they have can only be explained in terms of intoxication beyond that permissible level. Do you all accept that? You promise me that you can do that. Do you have any questions? Is there anything you'd like to talk about? When you talk to your husband about his cases, Ms. Ford, does he describe the situation that those come up in?
Not very often. Not very often.
Do you have much conversation at all with him about his work?
No, I really don't.
Let me ask you, if your husband has ever taken a position about something and just insisted that he was right, and you knew all along he wasn't? I mean, has that happened to you?
Yes, frequently.
Sort of to all of us. The fact that someone honestly believes that they're right about something doesn't make them right, does it?
True.
I mean, they can be mistaken. And in good faith. I'm not going to try and suggest that police officers will come forward and lie. Have some good friends who are officers. But they can be honestly mistaken, can't they?
Yes.
And you're willing to accept that as a possibility. Do you all promise me, and would you please raise your hands, that you will follow the law, that you will treat this case as seriously as if it were happening to you, and that you will see that justice is done in this case? Would you raise your hands? Thank you.
Juan, who would you strike? You get one strike.
Only one strike? I think it would be really tough. I sort of think that in the final argument, if I could remember enough quotations from the Bible, I could do Mr. Daly some damage. But I'm not sure. I mean, the indications were so strong that there is something inherently evil about a person who is drinking, that I think that would have to be the one. Mrs. Ford bothers me, but notice that his age is 48 and hers is 51. I think in this kind of a case, you've got a student. You'd like to have someone who's very young. And can you imagine students these days, except 1 out of 100 who doesn't get drunk from time to time? It's just, I mean, it's not in America. And so, the two age there were really a problem. And also, if your husband does hate his courses at the Attorney General's office, then what he talks about are sorry, sleazy, no-good criminals who are trying to get out of the penitentiary all day long. And anytime he talks about his work, that's what he talks about. And after a while, you just get to the point where everybody who's charged with a crime is going to lie or do anything to get out of it. And I think that if I couldn't get a challenge for cause on one of them, I'd probably get sick and fall down the stairs and ask for a new trial or something. Both of those people ought to be off the DWI panel.
How about you?
Well, you didn't notice, but we run a check on all our panels, and I found out this guy on the end has 3 DWIs and all kinds of stuff. We do run into that a lot. People don't often tell the truth on these forums, and without those little notes on the back of these things, I don't know what to do. I think that I probably would strike the law student. Again, that old, those are the bad guys, they're the good guys, they're trying to put everybody away kind of thing. Got real problems. When believe it or not, I go through a lot of inner turmoil when I have to strike a black person or a Mexican person for one reason or another. I always check those people out real well and try to question them real thoroughly, because I don't want to get into a thing where I strike people simply because they're black or brown. I just don't want to do that. A lot of people, you read the manuals I've read, at least in our prosecutor's manual, that there's a DWI case, you got a Mexican, get them off the thing right away. I just don't believe in that, and I don't do that. So I would spend more time with the black student. However, I'm not sure that I might have been, I don't know what it said your race was on this form. I didn't pick up on that, come to think of it. But I probably would have struck the student because he was a student. He's a 20-year-old law student, which means he's real smart, and or 24, right? Probably thinks he knows the law better than anybody else, and I think he might just swing the jury one way or the other, or just hold out to show him how much he knows. So I think I'd strike him, but it would really bother me that I have to strike him.
Do any of you have any questions for?
Can I make a couple comments or
Yeah.
something? I think that it's particularly insidious that the county attorney's office would send a Mexican down to try something like that. I would almost never strike a black or Mexican, and it got to the point where defense attorneys were doing that when I was a prosecutor. And it really sort of messes up because they're so full of, you know, sometimes what you do is gut reaction, sometimes what you do is everybody says this is the way. Some of the jurors' comments that I came in on, you know, and heard this evening, they don't fit the pattern. You got, you know, Hughes' comment wasn't, you tell me what that means, I don't know. I think that, you know, you can really, especially if you're careful about the age groups of ethnic groups, you can get some of them that are killers for the state. I mean, they'll just go for the death penalty. I wouldn't put my father on a jury for anything.
We had a case, just the Ken Oden trial, when Officer breath test refusal. It was a 54-year-old businessman who was holding out, and finally a 19-year-old college student secretary swung him around. She was gung-ho to convict this guy, and he just kept saying, I have to have more, I have to have more. And she finally single-handedly brought him around. If that just doesn't follow all those, read all these things, you know, it just doesn't work out that way.
If any of the students have any questions for you, would you be willing to stay for a reasonably short period of time to answer them?
My wife said I could stay till 9 o'clock.
Thanks a lot for helping us out. Appreciate it.
See you next week.